okay, I can see the numbers going up there. Fantastic numbers again. So thank you so much to all of you who've registered and those of you who are joining me live, and then obviously those of you who are watching either via our website or via our YouTube channel. It's always a pleasure to be with you. So we've reached April, Q2. I was chatting earlier to a colleague that it feels ages since I was with you for the March webinar, but it was only a month. But it feels as if so much has happened. And when I was thinking about a title for this month's webinar, I should have just called it just lots going on. So what we're going to do today in this webinar is really sort of cover off your April top 10. So what happened at the start of the month in terms of legislative changes. And I want to talk a little bit about an immigration update which happened in March. And then what we will do is we will have a look at a couple of employment cases which have come up, which I think are interesting, and things that maybe touch upon some of your own plans and some of your own key risk factors and areas of work as well. So for those of you who do not know me, I'm Emma O'Connor. I'm a partner in the employment team at Doyle Clayton, and I am also head of client training. If we are not already linked in buddies, then please do scan the QR code, which will magically take you through to my LinkedIn page where we can become friends. And I do try and link in with people after the session as well. So do sign up for LinkedIn. It's a way where I share kind of quick updates and tell you about courses and things that are coming up, but please do sign up as well. And I'll be sharing information later on after the webinar, actually, with how you can sign up for updates, because it's been incredibly busy. Maybe that's why it feels as if I haven't been talking to you for such a long time, because I've been off running lots and lots of training courses, and I just wanted to share some of those with you, just in case you thought, actually, that sounds really interesting, something we want to run as well. A couple of weeks ago, in fact, we ran the How to Have Difficult Conversations at Work course, which was absolutely fantastic. Brilliant tips and takeaways for how we can have difficult conversations, whether that be with colleagues, whether that be with clients, all transferable skills, super tips there. And I learned so much as well. So again, if that's something that you want to think about, again, think about all those tricky conversations that we have at work, managing exits, managing performance. And again, please do get in touch. And I will be running that as a public open course again in September. So if you didn't get the opportunity to book on to that course last week, then again, please look out for invites, but we can run it in-house. Managing probation, mastering probation, all those tips and things that we need to think about, engaging our managers in the probation process. How can we make those good decisions clearly, fairly, and avoiding what's coming down the track in terms of unfair dismissal rights being reduced to 6 months, and what does that actually look like, and how can we flex our processes and our procedures, and what are some of the legal risks that we need to be thinking about now, and also some of the legal risks that we need to be thinking about, obviously, as we move forward and have January 2027 on our radar. So again, managing probation, please do get in touch with me if you want to run that course for HR or your managers and leaders. Great feedback as well, so I can share that with you if anybody is thinking that sounds like the course for us. Employment Law 101, Back to Basics, again, a really nice course for HR. And again, we have lots of clients that join with international offices as well. So again, running that course for HR teams that have that international flavour as well. So please do get in touch. Managing sickness absence, again, going to be talking about SSP changes in a moment. Again, something to think about. And my Manager Essentials course is a lovely day-long course for managers. It really does take them through why they are important, what's their role in ER processes, so how can they be an investigation manager, what do they need to do if they're called to be a disciplining manager. When we ask them to manage performance, what does that actually mean, and how can they approach ER processes fairly, consistently, reasonably, And again, we talk about how to be an inclusive leader and an inclusive manager as well. So a really important topic, again, when we have our eye on those ERA changes that are coming through. And again, something I'm running for clients, which again, I think is a really interesting kind of, take on how can we support HR teams with what they are trying to do in terms of getting ready for the ERA and obviously the changes that came in April. And this is one that really is a nice course. It's a nice kind of update for managers. I can run it in person, running a lot of sessions virtually as well. And it really is thinking about managing through times of change. So again, what does that look like? Strategic HR, support, and what does the ERA mean for managers? And I love this course. The HR Masterclass is back for 2026. If you've not had the opportunity to have a look at the course, if you've not had an opportunity to have a think about your own teams, maybe you are somebody who needs a little refresher, maybe you've returned to HR after a bit of a break. Maybe you're thinking about your teams and thinking, actually, we've got some new joiners. We've got some junior or mid-level HR professionals that actually could do with a little bit of support. It's a really great day. I've designed the course to support HR professionals from both an employment law perspective and from an HR best practice perspective as well. You get my Doyle-Clayton casebook. We use quizzes, we use questions, and we really take attendees through, from what is an employee, who is an employee, what rights do they have, through then to how we manage, exit processes, how we manage grievances. And again, looking always at that horizon, what's coming in, what do we need to do, and how's that going to impact the way that we do things. So I'm running this course on the 13th of May in London. It is a day, so it's 9:30 till 3:30. I'm also running it from our Reading office and for the first time in our Bristol office as well. So I'm super excited to be sharing this course with clients and contacts in the Southwest as well. So again, those are the dates. The cost of the course is £499 plus VAT, but it really is a fantastic opportunity to come, join, meet, network, meet like-minded HR professionals, and again, go through guided topics with me. So again, I'll be sending out how you can do that. Really keen to get people booked. It is a small course. Again, the idea is it's running sort of a classroom style, but again, really great to have you join us. So I really look forward to seeing lots of you booking onto that course. Any questions, queries, you know where I am. Webinar next month, we're looking at sexual harassment and the changes that are coming in October. Twist on this one, also looking at it from a regulatory perspective as well. So again, do look out for the invites to that webinar. I'm going to be joined by Kate Capp and also our new regulatory partner, Benedict. So really excited to be able to bring that webinar to you. And off the back of that, Benedict and I are going to be running a new course looking at the changes to the non-financial misconduct rules that are coming in September. So again, if that's of interest to you, then please look out for invites to that course on the 1st of July. And again, we can run that in-house as well. Obviously, look out for the podcast. Do find us really great topics there that you can listen to. And again, you can find us on our website as well. So please do listen in. We've got a new one coming out on AI and HR tips and traps. So again, some exciting topics and just talking about things in a different way. 20-25 minutes. It's your drive home, it's your commute, it's your, walk to the train station, walk the dog. So please do listen to that. I'm live. This is a webinar. I am not giving you any legal advice. If you want to find out more, if you want to get some more help and assistance, then please do reach out and speak to me. So let's crack on, shall we, with our little basket of Easter eggs there and think about what has happened. Let's take stock. And I think this is really important. And what I'm sort of talking to clients and HR contacts about is really kind of breaking this down. Let's think about what's coming up now, what do we need to change in April, and then let's then think about and focus on what we then need to be thinking about October and then beyond. So let's break it down and let's really think about, and I'm going to give you your kind of April top 10. As always, this is a guide, this is an overview. You know, if you want to come and talk to me about contracts and policies and what this means for your individual business or your individual workforces, then again, please do reach out and speak to me. So probably the first change there is obviously looking at SSP. It is from, has been from the 6th of April, applicable to more of your workforce. The lower earnings limit has been has been completely removed. So we need to be thinking about who now is going to qualify for SSP. Again, SSP is payable at the rate of SSP, which increased to £123.25, or whatever the worker's salary might be, their normal pay over an 8-week reference period. So it is whatever is the lower amount. So again, we need to be looking at our payroll records. Have we got adequate evidence to be able to support what an individual's SSP payment will be, if again, they will be looking at that lower rate of payment there. Also, we need to be looking at our contracts, seeing lots of contracts at the moment and amending lots of contracts and policies, which obviously talk about the waiting days, which have gone. There are no more waiting days. Workers are entitled to SSP from the first day of sickness absence. So again, looking at processes, looking at policies, making sure that we've got training in there for managers we're looking at what our triggers are. I think it's going to be a lot of work around, really monitoring sickness absence and also thinking about the cost, considering that business impact. If we've got more people that are entitled to SSP, obviously from an earlier point from their first day of sickness absence, obviously we've got that increased business cost as well. So again, SSP, something to think about and something to really focus on. Next change, family leave changes. We've got 2 slides on this because we've got another family leave right that came in. This is obviously looking at paternity leave. And again, this becomes a day 1 right, although please note that the entitlement to be paid statutory paternity pay, again, the limit still applies there as well. So, and parental leave as well, it's still an unpaid leave entitlement, but again, that's going to be a day 1 right as well. So removal of that 1 year qualifying period of service. And also that weird anomaly which prevented, paternity leave and shared parental leave being taken in sort of certain combinations. And again, that's been removed as well. So we need to think about updating our policies on family friendly. We need to be thinking about reviewing our requests procedures as well, and generally making sure that our systems are up to date. We're keeping records of who's taken what and when, remembering there that parental leave follows the employee. It doesn't reset when they join you as a new starter. So again, increase that awareness amongst management population as well. So yeah, some key changes there to the paternity leave and parental leave as well. Also, we saw, again, we've seen that we've got some changes to rates of pay as well. So as you can see there, SMP, etc., has increased to £194.32 per week. Obviously, remembering, of course, for statutory adoption pay and statutory maternity pay, we've got that, additional rate of pay there that we need to take into account. But obviously, once the employee exhausts that and goes down to SMP or SAP, that is what they will be entitled to. But again, always check those statutory eligibility requirements, please. So again, making sure that payroll's been updated and making sure that obviously any policies reflect the new rates. Although as a guide, I wouldn't include rates in policies because it does mean you need to perpetually update them. So some rate changes there. I said there was another slide on family leave changes, and this is a new right that has come in, bereaved partners paternity leave. This is an unpaid right for eligible employees to take up to 52 weeks leave in the very sad event that the child's primary carer, so whether that's birth or adoption, should pass away during the first 52 weeks of a child being born or placed for adoption. Just to note though, it's not the full 52 weeks. It's whatever the proportion is up to either the child's, first birthday or first anniversary of being placed with the family. It is unpaid. There are some complicated notification rules depending on at which point the employee says that they wish to take this leave. So again, touch base on that. And also there are some, risks as well that we need to be focusing on, and rights that individuals have if they assert their right to take the leave or they actually take that leave as well. Very similar to what we see with other family leave entitlements, but it's really important just sort of focus on those and make sure that we don't trip up and managers don't trip up and get things wrong. So have a think about that one. Get in touch, whether you want to think about updating policies, having a new policy on bereaved partners' paternity leave. And again, just to remind you that this leave is unpaid. The Protective Award has doubled up to 180 days actual pay per employee affected. And again, this is in a collective redundancy situation. Always take advice, please, on collective redundancies, and particularly now when the stakes are, much greater with 180 days potential pay per affected employee. So again, please do take advice on that. And also remember that in 2027, we've got some new triggers as well when collective redundancy rules will kick in. So again, it's something that we need to be having on our radar in terms of what the risks are now in terms of, collective redundancy, and have we factored that in to our costs and potential risk analysis, but also thinking about moving forward, what that looks like in terms of the triggers as well. So really do kind of, really focus on this. Particularly if you've got larger organisations, maybe with, multi-site organisations, how is HR or operations teams going to keep track of the number of redundancies that are happening across the business? And that's going to be really key to, reducing risk when we think about the new triggers. So again, factor in the risk now, but obviously have an eye on what those triggers are going to look like next year. Whistleblowing and sexual harassment, talking a lot about preventative duties, sexual harassment risks, and as we know, we've got those third-party harassment changes as well happening in October, and then again we see the reasonable steps, preventative duty increasing to all reasonable steps, and again that's all happening from October of this year. So it's a really good time to start thinking about harassment, sexual harassment policies, processes. Can't recommend training enough on this topic. But as well as those changes coming in, and obviously the risk that we've got now from the 2024 legislation, we need to be thinking about the whistleblowing risk as well. So obviously whistleblowing now, sexual harassment has become a protected disclosure. Again, sexual harassment that has occurred, is occurring, or is likely to occur. So again, thinking about whistleblowing policies, thinking about how are complaints raised, if we've got those whistleblowing or confidential helplines, again making really clear that those individuals who are responsible for whistleblowing within the organisation understand that obviously whistleblowing and sexual harassment, there is a new protected disclosure there as well. So something really to focus on now, but obviously as we move forward. And please do get in touch if you want to talk about risk assessments. Always the key to this, the risk assessment, because if we haven't assessed the risk, how can we possibly then say that we've taken reasonable steps and then soon to be all reasonable steps? So again, sexual harassment is going to be a big area of focus for HR moving forward. Those of you who are, perhaps larger employers, but again, there's nothing stopping all employers from doing this. From 6th of April, employers are able to voluntarily, produce menopause support reports, or, focusing on gender equality as well across the workforce. So again, that's something that, employers can do voluntarily now if they so wish. There's quite a useful government guide, and that sets out, the actions that the government is recommending on that. So it's really worth having a look. And again, I can send that out to you if anybody wants to have a read. It's actually worth having a look, actually. So yeah, businesses are able to do that now voluntarily. But again, those larger employers out there, 250 or more employees, again, you will be caught when this becomes mandatory next year. Don't have a date when that will be, possibly April, but let's wait and see on that. So again, the government is saying, let's have a practice now. So I can see some sense in that. So, again, look at those internal trends, look at those internal reporting. Do we have data? And what are we doing in terms of supporting employees and women at different stages of their time with you? So again, voluntary now. Again, you may want to think about doing that now, but again, it's going to kick in later next year. Lots of rate changes. We know this sort of happens in April, so we're kind of geared up for it. But we know national minimum wage, national living wage, obviously that has all changed. The last, compensation for unfair dismissal has been released. It's going up to £123 and 543. There we go, or 52 weeks pay, whichever is the lower. As we know, it's being removed from the 1st of January, so we will miss it fondly, but there we go, that's been increased. And again, the week's pay as well, that has increased to 751. And in discrimination cases, the vento bans have increased as well. And really, this is a compensation guide to tribunals when they're awarding compensation for discrimination. It's really looking at the overall impact. So, for example, if the impact it's done in bands, so the lower band up to £12,000, 12,100 for again that injury to feelings. Again, the middle band up to 36,400. Again, looking at the injury to feelings, and that upper band could be could be 62,900. So it's increasing to 12,600, 37,700, or 62,900. But as we know, that cap can be removed in exceptional cases, which is why we say compensation for discrimination is potentially without limit. So we've got the vento bands there. This is one that sort of came in as a little bit of a curveball, really. And we knew it was there, but it was kind of like, there's so many other things with the Employment Rights Act. We weren't sure when it was coming in. And then, we sort of got a bit of a late entry into the April top 10. And this is really focusing on holiday pay records, but a bit of a sting in the tail is that a failure to comply is potentially an offence. So it is one that employers need to focus on, particularly where they pay variable holiday pay. Maybe you've got workers who, are paid variably depending on how much they work. So again, it's looking at workers being employers being able to demonstrate that they've got sufficient evidence, sufficient records to be able to show working time holiday. So again, we're looking at working time regulation holiday. So what is working time regulation holiday? What are your workers entitled to? How much, is their holiday pay? How much is being carried over and how much is being paid in lieu? So it's really thinking about the mechanisms and the way in which you're going to record that information. The regulations don't give a prescribed method for recording, but again, it's having sufficient records to be able to demonstrate that you've got the information to hand. Should potentially, obviously, we've got the Fair Work Agency as well, which is a bit of an amalgamation of different agencies and taken some powers away from HMRC, HMRC as well, with regards to sort of national minimum wage compliance. So it really is something to think about. Again, it's about businesses getting their ducks in a row. But yes, the Fair Work Agency, I expect that its powers will increase over time. But again, real, it's got some real teeth, the Fair Work Agency. So again, it's something to really look at. At the moment, they're kind of, working with ACAS, again, making sure that, policies and processes and things like that are kind of clear. But yeah, I really do think the Fair Work Agency is going to be one to watch. So again, get those ducks in a row, policies and processes. As I mentioned, I think this is one particularly, if you're sponsored, if you're a sponsor holder, the Home Office updated various guidance on the 6th of March. And this is really requiring employers to, again, demonstrate that they sufficiently inform their sponsored workers about their employment rights. I would urge you to take advice in terms of what this means and what this means for your organisation. Again, this is a very general and generic kind of overview, but I really do think you need to be taking some advice. What does this mean? What are you telling your workers and your employees at the moment? What do your contracts look like? Or your Section 1 statements, are there any gaps in terms of what workers and employees are being told? So I really would urge you to get in touch with the immigration team on that. And again, I can give you some details of how to do that. We're also getting a number of queries, both from individuals but also from businesses, about the ability for people working in the Middle East being able to come and work in the UK for a temporary period of time. So again, if that's something that's, you're thinking about something that maybe is going to impact upon your business, moving people from abroad, albeit temporarily, to the UK, then again, please do get in touch with the team on that, because they're working with a number of clients and supporting them. So just something to just have a think about there. Um, Again, mandatory ethnicity and disability pay gap reporting. It's something to have on the radar. Again, it's going to affect those larger employers. We await more details. Might come in next year, not sure. But again, it's just something just to, have there at the on the radar. Um, particularly if you are one of those larger employers. And then, we've got October, haven't we? And beyond. I mean, October is going to be a heavy month again in terms of changes, sexual harassment, third party harassment, trade union changes as well, that duty to inform employees about their right to join a union. Another big topic at the moment that, again, it's one where we knew it was there. What does it look like? Could it impact more employers than perhaps, originally thought? The consultation, or certainly the draft consultation, is out with regards to workplace access for trade unions. Have a look at it. It's something that I think employers, particularly if you're not used to having any union involvement in your organisation, I think it's worth just looking at it in terms of what it might mean. The penalties are quite steep if things don't go according to plan. So again, new rights of access, I think it's going to be something that we'll be talking a lot more about. Tipping changes as well. And then changes to the employment tribunal limit, to name but a few of the changes that are coming in October. And I think, again, the autumn's going to be a period when people are thinking about, what do those changes to unfair dismissal rights look like? What does that mean for probation periods? So again, get in touch. Got a really nice probation toolkit, probation training for managers and HR teams. So again, unfair dismissal changes 2027, fire and rehire, redundancy triggers. So again, a lot that is coming in 2027, but I think some things that we need to be thinking about as we move through to the autumn. But again, I'm here. We're going to be talking about things, giving you help and advice to guide you through. But I think certainly, over the summer and September, October, I think we need to be focusing on what January is going to mean. So again, name but a few changes, and also what would be great is to see lots of you joining HR Masterclass as well, so we can talk about some of these changes and what they mean as well. So I think now we're looking at opportunities, yes, but I think we're looking at strategic implementation. So again, if you think that coming in, doing a session for your managers would be useful, again, get in touch with me and can do that remotely. Rollout roadmap, what are we doing? We're supporting clients with contracts and policies, targeted workplace training. That strategic implementation. What does this actually mean for our business? Litigation support. Uh, I saw on LinkedIn, I think somebody had posted that a claim has been listed in one of the tribunals for 2030. So, that's really interesting. EDI compliance as well, harassment, sexual harassment. So please do get in touch with that. Workforce planning and resource management as well. So again, lots of ways that we can help, lots of ways that we can support you. Um, I want to just touch on just literally three cases. I felt today was probably more just have a bit of a recap and a debrief in terms of what happened at the start of the month in terms of legislation changes. There'll be more case law updates in the autumn and then moving forward next year as well. So there'll be more opportunity to find out what's going on. But just to give you a bit of a flavour in terms of what types of cases we've got coming out. So I thought this was quite an interesting one. It does maybe not to this sort of extreme, but workplace chats, teams at work, what are people saying, writing, what are the consequences of that? Maybe a little bit more of an extreme scenario. The individuals in this case were using a Teams workplace chat. There were some inappropriate things said. Yes, about sort of, kicking female employees in inappropriate places or maybe hitting females, and talking about good old days and other things that maybe, are not the most appropriate thing to be putting on a Teams work chat. The employer investigated the comments that were made, and the investigations team concluded that what they'd said could be deemed as inciting violence and hate against fellow BT employees. The employees were dismissed. The tribunal was asked to say, well, is this dismissal reasonable? The employment tribunal said no, it was not a reasonable dismissal because no reasonable employer, remembering it's that band of reasonable responses, they concluded that no reasonable employer would have dismissed the individuals for what they wrote. As you can see, the individuals there were awarded compensation. And really the takeaways from this are the tribunal were critical of BT because they said, well, look, this was such a business critical tool, but you didn't set any grounds or policies or training or notification as to how it should be used. So they're very critical of that. They were also critical of the fact that BT hadn't taken any other circumstances into account, so the way that people were working. Just to put this into context, this was during this case happened during lockdown. And again, this gives you a bit of an idea in terms of the backlog of cases as well. So they're very critical that BT hadn't looked sort of the wider context as well. And also one, this is really around the kind of the knee-jerk reaction, which we often see employers take. And really it's about, thinking about the investigation, and then going through the process. Is it fair and reasonable, that we're making the decision to dismiss? Is there another option that we have available to us? And again, please remember, employees will always say that they didn't know. So make sure that you've got clear communicated policies, you've got clear guidance, clear training on acceptable use of, internal comms, social media, email and internet. So one there that I thought was quite interesting. Again, it's coming up quite a lot, isn't it? Religion and belief. This was one where a potential Christian charity worker, they had their offer of employment rescinded because it was discovered that they had made comments on their Facebook post, Facebook, which the charity thought were incompatible with the aims of the charity. So they rescinded that job offer. The individual in question brought a claim in the employment tribunal based on discrimination for their religion or their belief, which, as we know, is a protected characteristic under the Equality Act. This case went to the EAT, and it's also been now, referred back to the employment tribunal to really look at the way in which the individual expressed their view, that manifestation. So is the way that they manifested that, was that objectionable? Was it genuine that the employer in this case acted in the way that they did? And is the less favourable treatment, i.e. in this case, the job being rescinded, that job offer being rescinded, is it proportionate to the way in which that individual expressed, manifested their particular religious belief? So again, it's not always that someone expressed something, the employer can therefore act. It's very much looking at the way, and again, this is following on from the Higgs case as well. So again, religion and belief, please take advice on it. Just really looking at that manifestation, the way in which the individual has expressed their views and their beliefs. Another case, again, this one has been around for a while, hasn't it? I remember I've been talking about this case for a long time now, but maybe we've got some resolution. This is around flexible working and indirect discrimination. This was a hospital trust which had a team of nurses, community nurses, and they proposed to increase weekend shift working. Ms. Dobson objected to shift working on the basis of childcare and the fact that she had an autistic child. It was not possible for her to rearrange her childcare to work at weekends. She was the only one out of a team of nurses who objected to the working arrangement. The hospital worked with her, consulted with her, encouraged her to put forward her views. She refused to accept the change and also provided no alternative to the proposed working arrangement, and she was subsequently dismissed. Now this case has ruled that yes, it's it's still the employer that has to, the burden of proof is on the employer, but the employment tribunal is entitled to look at the way in which the claimant has, have they put forward any suggestions or any solutions? And again, how have they put forward views and ideas that can maybe support the employer in achieving their aims as well? So again, flexible working case, they don't come up that often, but when they do throw up some really interesting issues, I think. So again, flexible working, changes are coming in as well under the Employment Rights Act. So I think this is an area where I think employers need to be thinking about, how are we dealing with flexible working requests? And how are we using those 8 statutory grounds if we are going to be saying no? So I think flexible working is another area that we need to watch. Get in touch. I'll be getting in touch with people. So again, you can, follow up on that, particularly around, getting in touch with our immigration team as well. I think that would be something to in particularly where you are whether you are a sponsored employer, there's some informations around that. There we go. So a couple of questions there. I will come back to you on that because I am conscious of time, but I've got some questions there around, the workers' holiday. Again, it's one where it's sort of, we knew it was sort of bubbling, but I think that's probably out of all the changes to the changes that came in April, I think it's one to really think about. And yes, Louise, I will send out a copy of the government guide to how you can, take those action plans forward. And there are some quite useful things in there for employers to really think about as well and to look at. So it's quite a useful document. I would recommend you have a look at it, even if you're not potentially caught by the regulations. It's always worth just to see, what government is recommending and steps that we can take to support our employees. So thank you very much for joining me today. Look forward to seeing you next month when we'll be talking more about sexual harassment. And again, if you are in a regulated environment, again, worth joining us to see what that looks like for you, changes coming in as I said, from September, so worth joining on that. Speak to me as well about the HR Masterclass. Really hope to see as many of you as I can in London, Reading, and in Bristol as well. But until I get the chance to speak to you again, I hope you all have a fantastic month, and I will see you again in May. Speak soon. Bye bye.